Good morning, good morning, good morning, amazing Leonard. We are gathered here early this morning. I know, we're going to say hear yous in a minute. We are gathered here early this morning. It's Thursday, it's December 18th. We are here for the sentencing of Brian Walshe. Yes, the jury just came back on Monday with a guilty verdict. Yes, sentencing is today. Why? Well, there's not a ton that needs to be done before sentencing in this case, and it was scheduled for yesterday and then put over for a day. I think it was put over for a day because, as we have heard the judge say numerous times, she wanted to make sure she had the impact statement that the children were working on with their social worker. Those are going to be impounded. They're going to be sealed. We're not going to see them. We're not going to hear them read onto the record. But the court wanted to make sure that she had them. And the court said that if she did not have the letters from the children through the social worker for the file, she was going to put over sentencing until she had them. I expect, given that it was just a one-day delay, that a little more time was needed to file those with the court, get them to defense, and get them sealed. So what are we looking at sentencing today? We know that Brian Walshe is going to be sentenced to life without parole. That's not discretionary. The court does not have a choice. If convicted of first-degree murder, then sentenced to life, period, LWOP, life without parole, goodbye. That's it. No options. Non-discretionary. The court does not have a range. But we have heard the defense bring up the issue a couple times, and the court said she was going to put over the issue until after trial of what the sentence is on the essential obstruction of justice. It's called something else in Massachusetts, but the lying to law enforcement obstruction to justice. Obstruction at... We're here for justice. Obstruction of justice count, because it is a 10-year sentence if it is obstruction on most crimes, but it can be a 20-year enhancement. And I'm curious to see if in Massachusetts enhancement means plus or enhancement means this is a elevated or enhanced sentence. It's more time. So that would be 20. If it's an enhancement like California uses the word enhancement, then it's a plus. I suspect it's a 20, not a 10 plus 20, making it 30, but we'll see. Is it going to matter at the end of the day? Well, there's appeals. It could matter for the purpose of appeal, but at the end of the day, he's got the federal sentencing that he needs to finish, a LWOP sentence, 10 or 20 years or 30. We can hope. We can just make it so it's and instead of or. But the defense was arguing that the 20-year enhanced sentence doesn't apply. Why were they arguing that? Well, they were seeming to argue that he was obstructing or lying with relation to the improper disposal, the improper uninternment of Ana Walshe, the improper burial, even though it wasn't a burial, but the improper disposal, for lack of a better word on at all. That count carries 3 years, and that's count 3. So the defense is arguing that count does not carry a life sentence. He was lying to police in connection with that. So because it doesn't carry a life sentence, he gets the lower one. The only reason that Ana Walshe's body was gone is because in the early morning hours of January 1st, 2023, Brian Walshe murdered her and didn't want to get caught and didn't want her body to be in the house. That's a life crime. So you get the higher one. Or at least that's how I see it. We'll see what the judge decides to do with that. I am curious to see if the judge sentences these concurrently or consecutively. I think they'll be consecutive after the other. I want to see the judge say that this starts after the federal case. Federal sentencing, consecutive. Then you can finish your federal sentencing. Then you can start your life, the rest of your life, all life. Today is also the opportunity for victim impact. We will hear the attorneys argue for a sentence. The defense can really only argue the discretionary sentences on counts 2 and 3. I think he's just going to get all of it. And then we will see if the judge has anything to say to the defendant. And we will see if the defendant has anything to say to the judge. I'm going to put up a poll in the chat about that. Let me know where you're coming in from, what you're drinking. And away we go. I'm going to roll the intro and we're going to go to court. Lawnards, it's good to see you. Are you guys ready? Are you ready to go to court this morning? It's early. We thought this was going to be yesterday. That's why we have the app. So we can let you know in the Law Nerd app when the schedules change, and we let you guys know that last night. So it's good to see you. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I think we have us queued up for the hear yees. Fingers crossed. Court didn't start right on time this morning, which is sentencing. We always give court a little zoom room. So we didn't start right on time either. We forgive. Time's a construct.
Hear. All present submitted for the Honorable Diane Freniere, Justice of the Norfolk Superior Court. Brian Walshe, your attendance shall be heard. Let's have a call of Massachusetts Honorable Court. Please be seated. What's down?
Your Honor, in the matter of the Commonwealth versus Brian Walshe, Norfolk Superior Court, criminal indictment number 2023-0091, defendant and
I gotta be honest. I was really hoping they were going to roll him in here in a jail jumpsuit. No need to be in a 3/4 zip suit. I was ready. I was ready for prison attire. They've allowed him to be in street clothes. I don't know why. I could only speculate rudely. It's not going to change. It's not going to change anything, right? But it's sentencing.
counsel present in court. Defendants represented by Attorney Larry Tipton and Attorney Kelly Borges.
I'm with you. I'm surprised he's in
Commonwealth is
street
represented
clothes.
by Attorney Greg Connor, Attorney Ann Yaz, and Attorney Tracy Cusick. Counsel
It is what it is.
starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yaz for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor.
Good morning.
Larry Tipton for Mr. Walsh.
Please be seated.
I'd love to see what the judge's face is doing. Dude, this is the
I
part
have two
to
motions up here, one from each of you, and I'll
this is the part to not be nervous about. This is the part where you just get the sentence that's coming. Like, there's no questions here.
address those in a minute.
You are unmuted.
Trish 104 asked, Emily, are all the documents the judge walked
So let
in
me
with
start
pertaining to
by-
this case? Yeah, that was the case file in this case for the court. Yep.
Excuse me, taking a drink of water. Let me start by listing what the court has reviewed in preparation for this sentencing to make sure that everything you think that I have reviewed, I have in fact received
Now
and
let's hear what
reviewed.
the court's reviewing.
So I've received the
Motions.
parties' sentencing memos. That comprises one sentencing memo submitted, I think, yesterday or the day before, late in the day before, from the Commonwealth. The defense has provided a sentencing memo along with a supplement that I received this morning. I think that was filed yesterday after the close of the business day. I also have received various victim impact statements in writing, to include victim impact statement on behalf of the three minor children from.
I think that's what the court was waiting for. I think that's why the 1 day delay. Remember, those impact statements are coming through the social worker that they are working with. I imagine that being the social worker working with the Walsh kids would be a difficult and heartbreaking part of that job. Not that social work is light and fluffy. It is often difficult and heartbreaking, but it would be hard to withhold one's own rage, I would think, at times. And I think that's why the court was delayed. I saw a lot of comments like, is he doing something to delay this one more day? I don't think so. The court said repeatedly, if I don't have those, I'm going to put this over. Government entities take time. So I think it was just 1 day to get it onto the court file.
The Department of Children and Family Services, DCF. I've also received victim impact statements written from Alyssa Kirby
Oh, good.
and from Peter and Pam Kirby.
So those are written impact statements that the
And
court has.
I sought out and shared with the parties and have reviewed various sentencing commission information,
So she's done some research.
as well as guideline calculation from probation, as well as Mr. Walsh's carry and triple I, which I'll talk about in a little bit.
The courtroom layout is still so just odd to me that you've got like, I mean, I'm used to the courtrooms where we're all like, all the counsel tables are just next to each other and then the judge, and then the clerk is kind of near the judge so the judge and the clerk can interact. It's so weird to me that it's like a waterfall from the judge's bench. It's like judge, clerk, prosecutors, defense. It's just so just different.
And I've now just received and will review prior to
The court's talking
deciding my
about
sentence.
the court's talking about all the standard forms that the court has up there. That's what the forms she's talking about. She's going to talk about them in a bit, as she said. So we're going to let her explain.
Letter from Diana Walshe. As an initial matter, is there anything that the parties submitted that I didn't just now list that you expected me or want me to review before sentencing?
Imagine the
Palmer
defense wants
first.
those motions.
Your Honor, there will be a victim impact statement given by Ana's sister, Aleksandra Dimitrijevic, and she's prepared to give that to the court.
So Ana's sister is going to be speaking in court. Brian Walsh's mother submitted a statement. I mean, I guess she's not making it in court. So we'll hear Ana Walsh's sister make a statement. I don't know if she's in court or if she is remote, but we'll see.
Okay, but as far as written materials, any other written materials that you are hoping me to review before I impose sentence?
No other written materials, and I just want to note that FTR is not on at this point in time, and I don't know if the court needs that on. I know we have a court reporter, and we're in good hands, but sometimes we've been running both.
FTR is the
All
recording.
right, I thank you for pointing that out. We do, when we have the court reporter, that is the primary method of memorializing the events, but always good to have a backup, and I see that Madam Clerk has put it on now. For the defense, are there any other written materials that you wish the court to review?
You have everything.
Okay.
All right,
Miguelina,
let me just take a moment.
Miguelina, when we get to the impact statements of Ana's sister, we'll let the app know as well. Murph Ann asked, will they read the statements? I do not know if the prosecutor will read them into the record or will summarize them. The statements of the children will not be read into court. Those will be sealed.
To review this letter.
So the court's taking a moment to review the letter. I'm just going to take a moment because we're going to need to zoom here real quick because we have been in trial and because trials are busy ones. All of you have been really just vibing with the case briefs. I know that those have been helpful to you. They've been helpful to me. I've been thankful to Team Baker. And one of the things that keeps Team Baker running is not only the game Midas Merge, but Midas Merge being a stream sponsor. So we're going to take a moment. We're going to thank Midas Merge. And then we're going to, while I zoom past the court taking a break to read all these things, I'm going to zoom and we're going to thank Midas Merge. All right? Sounds good. Lawnard, see you in just a moment. Lawnards, I know you love Midas Merge as much as I do, and some of you are very much higher levels than me in the garden, but guess what? We are getting a new location coming soon. So if you are ready to explore Firefly Valley, now is the time. It is a realm where there are fire spirits that dance through the night, more treasures to uncover, and enchanting creatures to discover and befriend. Firefly Valley looks like pure magic with all the things that I love about Midas Merge, including the fact that it doesn't time out. It's a game you can pick up anywhere because it works offline and it's ad-free and it's free to download. And Lawnards, you know I have a gift for you. For the first 200 people to download with my link or using the QR code, you'll unlock an exclusive Lantern Goat Level 1 directly from Firefly Valley. And yes, I got to name the goat. And what do you think I named it? And they wouldn't let me put scream noise, so we just called it Screaming. I know. I couldn't help myself. Don't miss your chance to step into this fun new fantasy land with our friends Screaming Goat and Lawnards. Don't forget to friend each other. I will put up a post if you want to share friend codes, and you can share them in the chat. So Lawnard, if you are ready to find out how your favorite game and mine just got more cute, it is time to download Midas Merge for free from the link in the chat or the QR code. And a huge thanks to Midas Merge for sponsoring today's stream. Let's get back to it. All right. Are you guys ready? Yes. So remember, for those of you that are downloading Midas Merge, it is the first number of Lawnards that download, and you'll see that in a couple days. I see lots of requests for no spoilers in the chat. I don't know if people are spoiling because I know the mods are probably busy, but let's continue on with the court because we were waiting for the court to finish reading. So we were waiting for the court to finish reading. I thought we were done. Nope. I thought I'd zoomed enough. I did not zoom enough. We're going to zoom together. It was harder to zoom because all the feeds that even say that they have closed caption don't, so it took us a minute. I love that the court's just on the bench doing her thing.
That you wish me to hear.
There we go. All right.
We'll start with the Commonwealth's presentation of whatever victim
The Commonwealth's presentation of whatever they're presenting. Begin.
impact statements that you wish me to hear orally.
Thank you, Your Honor. The Commonwealth would ask Aleksandra Dimitrijevic to address the court. Would you like her at the witness stand or from the podium?
In the witness stand.
Thank
The victim's sister is in court, and we are going to go to her impact statement now.
you, Your Honor.
The victim's sister lives. This is also another reason they may have delayed a day, is to allow the victim's sister to travel. The victim's sister is traveling in from out of the country. So it might have been that they also needed time for the victim's sister to get there, which is a fair thing. So if you don't have tissues yet, I imagine, look, victim impact statements are always heartbreaking. So I imagine that now is the time.
Good morning, Your Honor. Good morning.
You may be seated.
Thank you.
I appreciate that she brought her notes with her so that she can make sure she says what she wants to say.
Good morning, everyone. My name is Aleksandra Dimitrijevic, and
I really appreciate that the judge got up from the other side of the bench. This is a large bench for the judge. Got up from the other side of the bench and came to stand by the victim's sister and listen to her statements.
I'm the sister of Ana Walshe. I am here today to represent myself and my mother. I want to share with the court how losing my sister in January 2023 has forever changed our lives and left us with an unbearable emptiness.
Yeah.
Losing my sister Ana so unexpectedly has altered our world in ways we never imagined. Ana was not just my sister. She was someone I grew up with, someone who knew me in ways no one else ever will. I struggle with the grief that comes without warning, hoping every morning that this is all just a terrible dream. The most painful part of this loss is knowing her children must now grow up without their mother's hand to hold. They now face a lifetime of milestones, big and small,
She is looking
where
right
her
at the defendant.
absence will be deeply and painfully felt. This tragedy has also devastated my mother. She has developed severe depression and chronic exhaustion. Every single day, she carries the weight of losing her daughter. Our entire family is still learning how to live with this emptiness. Holidays and birthdays are now silent reminders of her absence. Because of the circumstances of my sister's death, we were denied the opportunity to say a final goodbye and to observe our customs, adding a layer of profound, unfinished grief to our loss. Ana was a mother, a daughter, a sister, and a friend. Her life was unfairly taken. We miss her beyond words. While we recognize that no sentence can bring her back, we ask the court to consider the permanent, long-lasting impact this loss has had on our family, especially her children. We stand in agreement with the Commonwealth and their recommendations. Finally, I would like to extend our deepest gratitude to the investigators, the Commonwealth's office, and everyone who has worked tirelessly on this case.
Great job.
Your dedication to seeking justice for my sister has provided our family with a sense of support during our darkest hours.
You're doing a great job,
Your
ma'am.
Honor, thank you for allowing me the opportunity to share the full weight of this incomprehensible act.
It's hard to put words to
Ana
that
will
kind of
never
pain.
be forgotten. We will carry her light and her memory with us forever. Thank you, Your Honor.
Thank you.
Thank you.
Your sister would be proud, ma'am.
Yeah. Thank you.
You did a great job. Where's the bailiff to help with the chair? All trial, the bailiff's there to help with the chair. And the victim's sister goes to talk and is fumbling with this chair. Bailiff! She looked at him a number of times during her statement. That is part of who the statement's for, not just the judge. Bro, the chair.
Your Honor, we have no other victim impact statements other than the ones that we've submitted in writing.
All right. Thank you.
The other victim impact statements submitted in writing are for the court to review. Sometimes the prosecutor will read them onto the record. Sometimes they won't. We'll see what they choose to do today.
All right. I have read the Commonwealth sentencing recommendation, the written recommendation, but I'll have you state it on the record.
Thank you, Your Honor. The Commonwealth is requesting.
The prosecutor took a big breath too. Again, it's a statutory sentence. And you can't sentence to someone to under the jail. Like you just, Massachusetts has an option. The option is LWOP. I mean, there's not much else you can do. Coco asked, will Brian hear his children's statement through his attorneys or will it be sealed from even him? The attorneys will have access to it. I don't know if he will choose to engage with that or not. They can't force him to.
That the defendant be sentenced to a series of consecutive sentences on the charges to run from and after his federal case in which you received.
Attorney Connor, I thought so too. That's what we want too. We agree with your second sentencing recommendations. Did you hear what he said? Consecutive sentences to be served after his federal case. Emily, he's getting life in prison, right? But you can only indicate to him what is thought of the things that he did in the ways that you can, which is start over after your federal crime. Finish your federal time and then start serving your life sentence. And then serve more.
To a series of consecutive sentences on the charges to run from and after his federal case in which you received a sentence of 37 months in February of 2024. The first charge that the Commonwealth would seek an incarceration component on is count 003, and that the defendant be sentenced to 2.5 to 3 years. The second.
He's going in reverse order. The sentence, the maximum on count 3 is 3 years. We've talked about the maximum on count 2. We'll see what he says it is. And then count 1.
Second charge would be that he, on the misleading 002, to run from and after 003, that he receive a sentence of 18 to 20 years.
No, just 20.
And that the third charge, the murder, and the first degree, that the defendant be sentenced to life without the possibility of parole to run from and after 003 and 002. And Your Honor.
Tina asked what a lot of you in the chat have asked, which is why I paused real quick. Will he go to federal prison first? No. The longer sentence will determine where he's housed. He will stay in prison in Massachusetts. I mean, he could go to, if Massachusetts has compacts with other states, he could end up in state prison in another state. But no, he won't go to federal prison first. He will go to state prison because it's the controlling sentence. It is literally a paperwork designation. Finish your 37 months, start your 3 years, start your 20 years, start your life sentence. It's truly symbolic. However, if there is an appeal, if there is time for appeal, then those things will still go consecutive after each other. But no, he's not going to federal prison and then back to state prison. So the reason it could matter down the road is appeal. I mean, Massachusetts could change the law. Massachusetts down the road could change the law and say, you know what? We get rid of LWOP on a first degree murder. We think they should have 50 to life or something. Massachusetts could change their laws. And so the consecutive also means that those things would all start and he would have to serve all of those first. So it would, if the law ever changed, if any appeals were successful and he got a new trial or a sentence reduction, then if they ever bumped his murder down to a second where he would get 15 to 25 to life, then those consecutive start to matter. If it's the 37 months plus 3 years plus 20 years, then you have to serve all of that first. So then it can matter. Because then if you add, 25 years on the end of that, how old's Brian Walshe? 50? So, yeah.
I may be heard in our argument.
Please.
Thank you, Your Honor. When you look at the facts of these 3 charges, each one calls for a harsh penalty.
Yeah, they're horrific.
If you look at the illegal conveyance of a body, the defendant did not just...
Count 3.
The person that he illegally conveyed was his wife and the mother of his 3 children. And he did it by removing her remains from the family home and placing them in buckets, in garbage bags, in dumpsters around the Commonwealth.
I guess we know what the prosecutors think happened with the buckets from Home Depot then, don't we? Because none of those were ever found. The leak-proof lidded buckets from Home Depot. Part of the reason that they are not going to try to force the defendant to talk about where Ana Walshe is because prosecutors and law enforcement believe that they know, and there is just nothing they can do to recover her. So that is some new information at sentencing here.
Legally conveyed was his wife and the mother of his 3 children. And he did it by removing her remains from the family home and placing them in buckets, in garbage bags, in dumpsters around the Commonwealth. He denied, as you just heard, her family the opportunity to have any customs or burial. There is no grave, there is no memorial. And he did this all in an effort to destroy evidence. On the misleading component, Your Honor, while we do mention the potential of probation, we put that in there only as data so that you understand the efforts that went in to trying to find Ana based on the defendant's series of lies. These lies were all done in an effort to cover up his crime and destroy evidence. We're also, while we put in that, we are not seeking a probation sentence, but we put it in there so the court if it wanted to contemplate one, understood there was an option to do it that would prevent the defendant potentially from trying to profit from this.
So the only mechanism for me, as I see it anyway, the only mechanism for me under the restrictions of state law,
Yes, Your Honor.
it's an either-or situation. That is, either I incarcerate him for an additional period of time, either concurrent or consecutive, or I put him on probation following the life sentence, or maybe it even starts today. But the only way that restitution can be achieved on count 2 is through a probationary sentence.
That's weird.
So I don't think there's
Can't he have to pay restitution if he gets a life sentence?
any other mechanism for me doing that. So I don't know how you achieve that goal if without a probationary sentence and mandating it as a condition of probation. And so I wanted the Commonwealth to be clear with me. You're making note of it in passing, but you are not asking me to put him on a probationary sentence. Is that correct?
We are not, Your Honor. It is data that you can use in order to determine the scope of his lies in which the police relied on them. And you can see the costs that went into investigating the disappearance of Ana Walshe.
Oh, he's not asking for probation. He included the amount of probation so that the court could look at the amount of cost to the Commonwealth. So they are not talking about victim restitution. They are talking about restitution for the cost of investigating him. However, you know how other jurisdictions handle this? You know what Florida does? And there are some cases where it might cause eyebrows to raise. There are some cases not. You know what Florida does? Florida charges you while you are incarcerated for the amount it cost to investigate you and imprison you. So the restitution, the prosecution is saying that they included so the court was aware of how wide-ranging the investigation was and how much it cost to the Commonwealth based on his lies, they are saying. So because of all of his fucking around, this is how much this investigation cost.
But we are not asking for probation on this matter.
And the same question with regard to the issue of restitution that I heard rumblings of yesterday.
Charge him restitution so when his mom puts money on his books for fucking beef sticks, it goes back to the Commonwealth. And just send it directly to Cohasset.
Yes, Your Honor.
Same result.
Same result. It is, again, it's data for you in determining your sentence, but we are not asking for it.
All right. Just wanted to be clear
Well,
on that.
Kiara, I don't think Florida would have had Karen Reed pay for Aperture because she was largely acquitted and got a non-prison sentence. Sarah Boone, on the other hand, restitution.
Thank you, Your Honor.
Adelson's restitution.
And then on the murder, again, this was the murder of his wife and the mother of his 3 children. And the cover-up of this murder, Your Honor, deserves some analysis. If you look at the first internet search, which occurred at approximately 4:52 a.m. on the 1st, how to dispose of a body, and how they evolve into eventually 11:24 a.m., how to dispose of body parts after a murder, it appears the defendant at this point in time is committed to getting rid of evidence of the crime. And it leads to the shopping sprees later on that night at Lowe's and CVS and Stop and Shop. However, if you look at the internet searches on the second, how to dismember a body and is a hacksaw the best tool to dismember a body? It's a reasonable inference he hasn't started the action yet.
Mr. Connor, I had a different inference, but we'll talk about that later. I'm glad we went with yours, though, versus mine. Mine is informed by the Shabusiness case, which is probably not helpful, but I'm interested to see where his argument goes with this.
And it results in the second shopping spree to Home Depot that afternoon, which means that Ana Walshe has been dead in that basement for over 24 hours. The same home his children are in, the same home the babysitter's at, the same home his mother has come to visit. And in the evening between the second and the third is when the dismemberment occurs, And on the third, we see him going to dumpsters, getting rid of the remains. In the defendant's sentencing memo, and I want to note, the defendant was represented by two excellent lawyers who are titans in this industry, who I have the highest respect for.
However, I have the utmost respect for defense. However,
say the Commonwealth's recommendation is inhumane. I suggest that that's not the appropriate word choice. Because if we were to look at that word, I would suggest that that describes the defendant's actions and the depravity of his actions of murdering his wife, dismembering her, and getting rid of her remains by throwing her away like garbage.
Yep.
The question might become whether or not this is a cruel and unusual punishment that the Commonwealth is recommending.
What? No one's going to argue that. Tell me no one's going to argue that. Also, Connor didn't get a chance to make a closing argument, so I think we're getting a little bit of a indication of what that might have been like. But I don't think anyone's going to argue that LWOP in this circumstance, on these facts, for this case, is outside the scope of what our society tolerates for reasonable punishment for the crime committed.
And I direct your honor to one case. It's Cepulonis, Cepulonis versus the Commonwealth, 384 Mass 495 at 497. It's a 1981 case. To reach the level of cruel and unusual punishment, the punishment must be so disproportionate to the crime that it shocks the conscience and offends the notion of human dignity. I don't know if that's possible in this case, Your Honor.
No.
Because
the defense's actions shock the conscience and human dignity.
Human dignity was completely offended by the defendant's actions,
right,
and how he treated his wife, how he disposed of her, and how he robbed her family and friends of the opportunity to bury her. There is no death certificate. The church will not allow a funeral to go on at this point in time. We are working on trying to work with the ME's office to see if we can get a death certificate to issue now, based on the conviction and based on the plea. And when I looked behind me after the closing arguments, I realized that was the closest thing that those people had come to a wake, because they never got together to mourn her. And that happened 3 years later. So with that, Your Honor, the Commonwealth does make a punishment that we recommend to you. We recognize it's harsh, but we think it's appropriate based on the facts. And I appreciate your time, Your Honor. Thank you.
Thank you.
This was a missing person case. And for some, it was a missing person case up until trial started, because until trial started, the defendant was maintaining that his wife had gone missing. Even some of the articles during the trial and after the conviction, even then, some of the articles were still saying missing Cohasset mom. That's not the facts here. So I'm glad to hear that the prosecution is working on a solution for the death certificate so that the victim's family can observe some type of ceremony and burial for her. The reason that they can't is because of what the defendant did.
I'll hear from the defense.
Okay.
With respect to the first-degree murder conviction, although we made it clear from our memorandum that we do object to a life without parole sentence based on state and U.S. constitutional grounds, based on the Eighth Amendment, we understand the court has no...
The defense, we are making the argument, look, the defense is holding that argument for appeal. If you don't make the argument, you can't appeal it later. And at some point down the road, could Massachusetts do away with LWOP? Sure. Rules change, punishments change, cases change. And if they don't preserve it now, it makes it a little harder. But yes, she's not arguing vociferously. Your Honor, we're making the argument for the record. We know you can't do anything about that.
Discretion with respect to indictments 2 and 3, you do. I think inhumane is the right word, respectfully. To sentence someone to prison posthumously to send a message is humane. It's dehumanizing him.
See, ma'am, yeah, no. At least he'll have the opportunity to be buried when he dies in prison.
Regardless of what happened in this courtroom, regardless of the convictions, regardless of what anyone believes about this person, he is a human. He is a father, he is a son, and he has been a friend to many. The life sentence is mandatory, but to do consecutive sentences, I think, is inappropriate and is inhumane. Anytime there is a death, a murder, a loss.
Buckets, counsel. Buckets, counsel. Buckets and a hacksaw. Okay. Look, defense attorneys have to do their job. I mean, Ariana said harsher things to Tom Sandoval.
Loss of life, it is horrible, whether it's a loved one or a stranger. And the legislature has provided, regardless of our disagreement, that a life sentence without parole is mandatory. But that does not negate that he is a human being. And I don't think sentencing him to on and after time is appropriate. Just because you can.
Oh, yeah, she definitely should. The judge should definitely sentence him consecutive to everything. I mean, the judge isn't going to end her soliloquy with, and I hope you burn in the pits of hell. I mean, she's not going to do that. But no, the judge can sentence him consec. I have some fairly strong feelings on that. But it's really hard to talk about dehumanizing someone in this particular case, given the facts that are on the record. So it's this argument. This argument is real tough. This argument is real tough for me.
Doesn't mean you should.
Yeah, she should.
What he was convicted of were atrocious acts. We've heard from her family. We've heard from her friends. Their pain is unimaginable, and I'm not demeaning that, but I have the opportunity to speak for Brian today. And I'm asking the court to sentence him in line with the guidelines and with the purpose of sentencing.
Chat would
punishment,
like to send a message
justice,
to Brian.
Prevention of future crimes, consecutive sentences, that's excessive and it doesn't meet those needs. So I'd ask the court to adopt the defendant.
Well, counsel, he's going to die in prison either way. I don't think it's excessive. The restraint the chat is showing and not name calling this defendant is admirable. Thank you, chat. I'm with you.
Sentencing recommendation.
So the defense sentencing recommendation is life and then everything else concurrent? No. No.
Just want to put on the record that
there are plenty of defendants who deserve a second chance in life. I would say most defendants deserve a second chance. This defendant deserves to pay for what he has done. And since Massachusetts says that the way to do that is life without parole, then everything should be consecutive. Period.
the defendant, in making its argument with regard to inhumane the inhumane aspect of any consecutive.
Okay, back to legal commentary and not just Emily Rage. There are some cases where the facts just shock the conscience. This is one of those cases. And it's very difficult for me when the defense stands up and argues, but this person sitting here is a human being. Yes, ma'am, we can see that. Flesh, blood, breathing. But the actions that he took are difficult for society to recognize as actions that one human could commit upon another human, especially a human that they swore to love and honor and protect. So even if he did not have love and care for his wife any longer, he did not love and care and protect his children. So to stand in court and say that he is a father, a husband, and friend to many is real tough. Ana Walshe is gone. But her children are going to have to live not only with people knowing what happened in their home, but one day they might see what the prosecutor has said here. And they're going to see the police statements of their father talking about how he was getting up in the morning like everything was fine and making them French toast. And while he said he was doing that, his digital devices show that instead he was Googling how to dismember their mother, who is apparently still in the fucking basement because he murdered her. So the things that they are going to have to struggle with are inhumane. He did that. So no, get all your consecutive sentences and be mad. Be mad, just be mad. Because I don't know how, other than completely tucking it away in a corner of your brain where it never comes up again, I don't know how you even process that. And I hope that for a very long time, if not forever, the kids don't have to process that. However, I also have a junior high school student and a high school student. I know that some things are true, and that is that children growing up can't be protected forever, and kids can be assholes. So I worry. I worry for their kids. Brian Walshe worries for himself. There were a lot of arguments you can make to the court about asking for concurrent sentences, not consecutive. Inhumane is a tough one for me. It's a tough one for me. All right. I want to hear what the court has to say. All right, Your Honor.
Inhumane.
The court's going to address the cruel and unusual punishment argument made by the defense. And I'm going to try not to crash out any further.
Defendant, in making its argument with regard to the inhumane aspect of any consecutive sentences, cited to a case in its brief, Donovan. Donovan does not apply to this case. As an initial matter, Donovan related to a larceny involving a single act that resulted in 7.
Ms. Porges, you cited a larceny case about the 8th Amendment? A theft case? Ma'am.
Different victims being victimized. The SJC, that was, I think, a 1985 case.
SJC is Supreme
The
Judicial
appellate
Court.
courts in Massachusetts have long since distinguished Donovan, even in the case of larcenies, which is not the case that's before me.
The defense's face is
To
giving. We tried our
recognize
best, Your
that
Honor.
Even Donovan relates only to a single act case and not one
Giving,
with
we tried.
one purpose. As you could argue, there was one purpose here, but more than one discrete offense. So I'm not persuaded by the logic of Donovan,
Fair, Your Honor. Truly.
even if it applied to this case, and even if it was as broad-reaching as the defense suggests in its sentencing memo, which the court finds it is not.
In most jurisdictions, this would have been a DP case. The facts of this case, in jurisdictions where they have it, whether it's implemented or not, in a lot of jurisdictions, these facts would have pushed it even with a no body case. A lot of jurisdictions that's where that would have been. So I would like to see the judge, though, Your Honor, because I literally can't. Your Honor, can you order the cameras to stop with him? It doesn't help with the rage and the no name calling. Like, at all. And if the judge doesn't go full Newman, which she might not, I may. Not that I haven't kind of already. I'm not done with uncharitable things to say to the defendant. Kristen asked in the chat, and many of you have, why is he still permitted to wear street clothes? I don't know. Mass things? Maybe because it's on camera? I don't know. I mean, he's not getting a matcha with his 3/4 zip, but I would have made him roll in oranges. And chat, when you're like, I just want to hear Emily go off on him, don't worry, we'll do that again later. But this is why judicial demeanor would be difficult for me. Because there are some things that are so horrific. And then you see this defendant sitting there for 3 years lying about where Ana Walshe is. And it's real hard to maintain the balance of
There is
judicial
no task
demeanor.
facing a judge that is more important or more difficult than crafting an appropriate sentence. The legislature mandates that the only appropriate sentence for the jury's verdict, murder in the first degree, is life in prison without the possibility of parole.
Okay, we're getting to the judges.
That sentence
Sentencing.
is immensely appropriate and just, given your murderous acts and the life trauma that you've inflicted upon your own children.
Get him, Your Honor. Get him. Get him. Just get him. It's kind of cathartic, isn't it? When the judge is like, I see you. I see you, and I'm going to tell you what I see. We're going to back it up. Chat needs to hear from the court. Thanks, Your Honor.
The legislature mandates that the only appropriate sentence for the jury's verdict, murder in the first degree, is life in prison without the possibility of parole. That sentence is immensely appropriate and just, given your murderous acts and the life trauma that you've inflicted upon your own children. As to counts 2 and 3, I have wide discretion in sentencing. I want to state my rationale for your sentences on those 2 counts on the record now. I have considered various factors with regard to my sentence for counts 2 and counts 3, to which you pled guilty on November 18th, 2025. Specifically, I've considered the severity of the crimes, their nature and circumstances, and your role in those crimes.
The nature
The
and
need to
circumstances
deter
are
others from committing comparable crimes, and your prior criminal record, namely your federal fraud case.
When the court talks about appropriate sentences to dissuade others, there are few cases that you look at and say, if there is any case to send a strong message on, you know how I feel about Courthouse Becky, elected official. Trying to set the stage to not be able to be prosecuted for murder because you have disposed of the victim is at the top of behavior that needs to be dissuaded. It shouldn't make it easier for you to get a lighter sentence. It should ensure that what you get is a stricter sentence. I agree with the court.
As to the latter, your criminal history shows a long and well-documented history of
being a liar
and manipulative behavior.
Deceitful's the word that bothered you in all of this? Really? For all of you listening in the background, I'm just responding to the defendant's facing. But yeah, your federal case shows a pattern of deceitful behavior.
Others from
I backed it up.
committing comparable crimes, and your prior criminal record, namely your federal fraud case. As to the latter, your criminal history shows a long and well-documented history of deceitful and manipulative behavior. I've considered your character, or lack thereof,
Woo!
your behavior, and your background.
She's big bad. She's
With
big
regard
bad,
to the nature and circumstances of the offenses, as to indictment 002, in the approximately 4 hours of interviews spanning 4 days, you concocted a detailed, completely fabricated story of what happened to Ana Walshe on January 1st, 2023, in order to cover up your murder of her and disposal of her body.
So he's going to get the max on that based on what the court is saying. That's the vibe that she is giving. The court is making the record for the sentence on count 2, which is the obstruction of justice. Because of where my camera is, it is very hard to see Tipton, but he's just kind of, Tipton's there. Just kind of sitting there as the court pronounces sentence. The court's not happy with the defendant at all.
Your lies triggered a multi-day, extensive missing persons investigation. A command center was set up in Cohasset and was manned by various law enforcement, to include the Cohasset Police Department and the Massachusetts State Police. And local and Massachusetts resources were deployed to Washington, D.C. to investigate at Ana's home. Because of your lies, thousands of hours of investigative resources were wasted and diverted from other deserving cases and investigations. As to the nature and circumstances of count 3, the improper disposal of Ana Walshe's body, the seriousness of your acts cannot be overstated. Your acts in dismembering your wife's body and disposing of her remains in multiple area dumpsters can only be described as barbaric,
depraved,
and incomprehensible. You had no regard for the lifelong mental harm that your criminal acts inflicted on your then 2, 4, and 6-year-old sons.
Yep.
Not only in taking their mother, but also, as is specific to this charge, in never being able to properly grieve that loss, to say goodbye to their mom. And I hear today the same is equally true of a sister who never was able to say a proper goodbye to her sister, a mother who never was able to say a proper goodbye to her daughter, and many friends who had the same loss. As to indictments 2 and 3, I have considered the sentencing guidelines, the aggravating factors. There are no mitigating factors in this case.
Oof.
And I also sought out and considered information from the Massachusetts Sentencing Commission, again, which I shared with the parties earlier this week. In particular, sentencings in 2022 and 2023 of defendants who were convicted of murder and or voluntary manslaughter, along with a Chapter 268, Section 13B conviction.
Yeah, the court's not happy with Brian Walshe. The court is also making me as emotional as the impact statements, but the court's saying there are absolutely no mitigating factors. I agree with the court, but the court is making a very thorough record. I think it's just going to be max consecutive. I think the court's like, I can't do more to you, but I wish that I could. That there are a few cases that is the feeling. This is one of those cases, because truly there is no earthly punishment that rises to the level of what this defendant did. There just aren't.
This is not a guideline case. Finally, as to the first-degree murder conviction, I have considered the loss of the life of an innocent, remarkable woman, Ana Walshe, and its devastating impact on her children as relayed to me in the letter from DCF, her family as relayed to me in her sister's victim impact statement today, friends in their victim impact statements in the community. In the trial testimony of Jem Mutlu and Alyssa Kirby,
Their
a
testimony
little
was
bit of
heartbreaking.
Ana Walshe, her warm, powerful, and embracing spirit came to life in this historic courtroom. I
That's
have
a good way
carefully
to say it.
listened to the moving victim impact statement, to the oral written sentencing arguments made by the Commonwealth and by Mr. Walshe. It's clear to me that Ana was a bright light in the lives of many people. She lifted people up. I am sure that nothing I say and no sentence I can impose.
She said, and by Mr. Walshe, but his mother submitted an impact statement. I'm just going to back that up again. His mother submitted an impact statement. I just wonder if she meant Mrs. Walshe, because we heard that was submitted for the record. I'm just going to back it up to hear it one more time.
A little bit of Ana Walshe, her warm, powerful, and embracing spirit came to life in this historic courtroom. I have carefully listened to the moving victim impact statement, to the oral written sentencing arguments made by the Commonwealth and by Mr. Walshe. It's clear to me that Ana was...
Sorry, the court had moved on to discussing the arguments made by Walsh's attorneys. So, I mean, it is the defendant through his attorneys. So that's when she said, and by Mr. Walshe, she's referring to Attorney Porges' statement. I just needed to back it up. I was so confused for a minute, but it's the impact statements taken together, the arguments by the Commonwealth, the arguments by Mr. Walshe. She just didn't say the defense, but the arguments of the defense. That's where I got confused.
A bright light in the lives of many people. She lifted people up. I am sure that nothing I say and no sentence I can impose, even a life sentence, will lessen the grief that Ana Walshe's family, her mother,
That's true.
sister, and 3 boys extended like family, confidants, friends, and others have endured and will continue to endure. Although I consider the letter of Ana Walshe, I simply cannot reconcile the person Ana Walshe describes in her letter with the person who stands before me.
Oh,
for
boy.
sentence. Mr. Walshe, you can stand.
Stand to be sentenced.
Mr. Walshe, you will live with the guilt and burden of Ana Walshe's death for the rest of your life. As to count 1, the jury having convicted you of murder in the first degree, I sentence you to life in prison without the possibility of parole. As to indictment 2, lying to the police in connection with the investigation of a life felony, I sentence you to no less than 19 years, no more than 20 years, the statutory maximum, in prison to be served consecutive to the life sentence in 001.
Consecutive. Though it feels symbolic because he's getting a life without parole sentence, it can matter based on appeals, changing laws, what have you. But it's consecutive with no less than 19 years, no more than 20. I imagine the next count will be what? No less than 2.5, no more than 3, because count 3, the max is 3 years. We can have that conversation another day. But I want to see if it's also all consecutive to the federal case. The judge's tone speaks volumes, doesn't it?
The legislature caps the maximum sentence for the improper disposal of a body at 3 years in state prison.
Which is wild.
As to indictment 003, the improper disposal of the body of your wife, Ana Walshe, I sentence you to no less than 2 years, 364 days, and no more than 3 years in state.
The court's range for count 3 speaks volumes. I sentence you to no less than 2 years, 364 days, but no more than 3 years. 3 years minus a day to 3 years. Did the court have to do that? No. Did the court choose to do that? Yes. All. She can't sentence him legally to all. That is not a proper sentence. The court is going to get as close to all as humanly possible. And I am here for it.
Prison to run consecutive to the sentences in 001 and 002. I want to make one other notation with regard to the sentences that I'm giving today. Earlier in this case, I identified that there was an error in Mr. Walsh's III. That error persists to today. Specifically, so the record is clear, as I understand Mr. Walsh's prior federal sentence, he was sentenced to 37 months in federal prison. That sentence was to run concurrent with any state sentence that was given in this case. This morning, I asked probation to run his III again, and it is still incorrect. It is showing a 5-year probationary sentence.
Probation. He got time. Also, why are Emily, you know why the feds are sentencing him to concurrent time. They do not treat fraud cases the same as violent crime. Calm down. She is talking about the name of a probationary form from Massachusetts, like a sentencing report. That's just the name of the form. So they ran the federal case And it sounds like sentencing or probation or whoever does the sentencing reports in Massachusetts, they can be done by different entities. But the report that the court gets, that is what she is naming the triple I, because it's probably literally I, Roman numerals instead of just 3. Anyway, the form that is run prior to sentencing here, she is saying is reporting the federal sentence wrong. That wasn't a probationary sentence. It was a prison sentence.
In this case, this morning I asked probation to run his triple I again, and it is still incorrect. It is showing a 5-year probationary sentence. At my direction, the probation department in the last month, or perhaps a little bit longer, contacted the federal probation office in Boston.
Oh, Your Honor, I appreciate you. The judge is like, no. Call the feds. Get this shit right. Good job, Your Honor.
To correct what I think is an obvious error in his triple I. It has not been corrected, and it stands still today as showing 5 years of probation.
Get it together, everybody.
To the extent that confuses anything in my sentencing, I want the record to reflect that, again, it's my understanding he was sentenced to 37 months in federal prison to run concurrent with this sentence that I'm now imposing today.
Well, boo. Should be consec. Emily, does it matter? No. It's just somewhat vindicating.
Madam Clerk, you may impose the sentence.
Thank you, Your Honor.
So this is the clerk's formal imposition of sentence that the court already delineated. Well, at least when he stands up, we can see that he's still cuffed in court. Not for nothing. Yeah, Chad, all of you that are saying that you like this judge, I really like this judge a lot as well. She has been very even keel. She has ruled pretty swiftly on the things we've watched.
Jury having returned a
She's
guilty
easy to
verdict
follow.
on charge 1, murder in the first degree. You were sentenced to the state prison for the term of your natural life. Count 2, witness intimidation. You having entered a guilty plea to that, sir. You're sentenced to 19 years.
I don't understand many things in Massachusetts. I do not understand why their obstruction of justice count is all combined into their witness intimidation count. I do not know. But it is one count and it involves lying to law enforcement, and it is, I think they should be separated out because they are very different things, but that's why the title of the count is confusing. But it is being used as obstruction of justice. So it is not an obstruction, it is being used as obstruction of justice, even though the title of the count also involves witness intimidation. I'm not a legislator. I don't know. I feel like this one could be fixed. Just parse it out into 2 things. But it is witness, juror, police, court official intimidation under 268 subsection 13B. I don't know why it's all just blended into one code section. Not my circus. But legislature in Massachusetts. Get yourselves a separate obstruction of justice charge, because I guess they look at intimidating a witness as obstruction of justice if you're intimidating them so that they don't go to court. I can see the logic. It's just confusing.
Not less than 19, not more than 20 years to run from and after your life sentence on count 1. On count 3, improper disposal of a body. You are sentenced to not less than 2 years and 364 days and not more than 3 years to run from and after the sentence on count 2. You will receive 1,076 days credit for time deemed served while awaiting the disposition of this matter.
Oh, Madam Clerk, I feel
in
you.
this matter are waived. You're all set, Mr. Walsh. Thank you.
Madam,
Thank you,
I heard it,
Counsel.
Madam Clerk. That is the defendant's mother in court. And as they turn around to walk out of court, you can see that it does appear that there are more people in this courtroom than there have been during trial. This was not the fullest public courtroom we've seen, but fuller than most. So as we watch them walk out, we'll summarize a bit before we move on to questions. As they walk Brian Walshe out of court past his mother, who the court spoke directly to in her statements.
Goodbye.
Well, some days the call-in system just sounds kind of eerie. And, you know, I feel like just for the law nerds, one more time in Massachusetts, the only fan, the other only fan. I mean, the goodbye is wild, right? All right, law nerds, let's talk real quick about the sentencing. We did not see Brian Walshe speak at the sentencing. I imagine that was either already discussed with his attorneys prior to the court, because the court didn't even ask, will Brian Walshe be making a statement? There was no question about it. The prosecution and defense argued for what sentences they wanted to impose, but ultimately the court's strong statements against the defendant's actions, indicating that there was no mitigation in this case, and making it very clear that this is a case where the maximum potential sentence, consecutive after one another, is the only appropriate remedy, even though the defendant will be incarcerated for the rest of his natural life, as the clerk told him when the clerk officially pronounced sentence. So what did the court sentence Brian Walshe to? Well, life without the possibility of parole on count 1. On count 2, the obstruction or lying to law enforcement, no less than 19 years, no more than 20, which clarifies that the maximum on that is 20 years. And then on count 3, the disinterment of Ana Walshe, the court sentenced him to 2 years, 364 days at a minimum, 3 years at a maximum, consecutive. That sentence lets you know exactly how the court feels about this case. And we saw the court comment on the defendant, his actions, and his long history of, well, lying, which seemed to be the only thing that elicited a reaction, even though it was not as large of a reaction as we have seen. We have seen some very small responses from Brian Walshe in court, including the way he reacted to the court commenting on his federal case. So, what comes next? Well, the defense may make another motion for new trial. They may just go straight to appeal, but there will be an extensive appeal process in this case. We will see if any of Ana Walshe's friends come forward in the days and weeks to come to share their memories of Ana Walshe. And the court talked about how humanizing to Ana Walshe it was when Jem and Alyssa testified in court. And I think the court noted that particularly, not just because it was, but I think it was the court's way of acknowledging the difficulty of coming into court, sitting face to face with the defendant, and giving your testimony. I also think early on in the case, we saw glimpses of that with the woman who just had a kind of chance conversation at the nail salon with Ana Walshe, the people who worked out with her. We got to see glimpses of her throughout the case. And though I am and remain deeply frustrated by the fact that some of the victims' photos in court were just in evidence the way they were, some of them were blurred, I also understand the courts going quite a long way to protect the constitutional rights of the defendant, because after all, a criminal trial is about protecting the constitutional rights of the defendant first and primarily. And that can be a frustrating balance when it feels like the victims get lost in that pursuit. And I think the court, though I was personally frustrated at times, I chose to work as a prosecutor for a reason and did that for a long time. But though I was personally frustrated at times, I think the court has done everything that they can to protect this from appeal, because at the end of the day, allowing this case to be final and the sentence to stand is the best way they can protect all of those grieving in this case, so they do not have to do it again, even when it's frustrating. Again, I rather them do it right and make sure that they protect it. And this court and these attorneys well know the temperament of the appellate courts and the Supreme Judicial Court in their district more than me. Though I agree with you, Chad. At times it is very disheartening to see photos of the victim that are blurred. It's frustrating. But making sure that the defendant goes to prison and stays in prison, and that the state of Massachusetts does not have to try this case again, is a valid reason to make those rulings. The court made the rulings throughout this trial, because a lot of you are going to ask me what will be the grounds for appeal. The defense will find them. But I think the court's rulings were restrained. I also think that the prosecution, at times to my own frustration, because of course, at times the prosecution, I think, was quite restrained. There was more they could have commented on that they didn't. There was more they could have done that they didn't. I think they protected the record in this case from appeal the best that they could. And I have not seen anything on this record, and we have not looked at all the pretrial. I've not seen anything on this record that is going to, cause me grave concerns, to borrow from another courtroom in this courthouse. So when this goes to appeal, we'll look at it together. That will be the appropriate time for us to look together at some of those pretrial rulings that we have not covered. I'm curious. A lot of you have asked me about the pretrial rulings. We will get to see those rulings when we start looking at the appeal, and I will look at the appeal with you. I think that that is the appropriate time to follow along with this case a bit. A number of you said in the chat that one of the jurors came forward. I think now is the time to take a look at that together, and then we will go through some of the questions. Does that sound good? Does that sound good to all of you? I hope so. So at the end of the day, Brian Walshe is sentenced to prison for the rest of his natural life. I think the questions that will come next will be, will the court, or will there be access to some of the evidence in this case? Some possibly, but not all of it. Will we ever see and the law nerds wouldn't ask this, I think the broader internet might, but will we see the impact letters? Those will be part of the record that people can see, not the children's. So if we see the letter that the defendant's mother wrote to the court, we will absolutely cover that. I am also curious. And I'm not going to stop following the civil case involving Brian Walshe's mother and their landlord. We're going to follow that for sure. But the court did make a particular note to say that she could not reconcile the things that the defendant's mother said in her letter and the person standing in front of her. I will try to not judge too harshly out loud, but my feelings on that may change if there is more information we know about the defendant's mother from, well, Alyssa Kirby, for one, because it does not surprise me that the defendant's mother, from everything we have seen, is still maybe in a bit of disbelief. I don't know if that's a protective mechanism. I don't know if that is a fervent desire to not take into account the facts in this case. I don't know. But it is hard for me to wrap my mind around the fact that Brian Walshe's mother was sitting in court through this case and through this evidence and through the prosecution's statements with more information today than we've heard in other court hearings about how Ana Walshe was disposed of. It's hard to reconcile that someone can sit in court and see everything that we've seen and still disagree. Then again, I've existed as a human that has access to the internet. And so I have seen how people can look at one thing and say, no, that thing's something completely different. It's just hard for me to wrap my head around. But that will be public, and if we have access to it, we will go over it. It'll probably just make us mad, but we'll go over it anyway. The court did not take it deeply into account, and that does not surprise me. But it was interesting for me to hear that the court looked at that federal fraud case as the defendant's history of deceit and noted that to the lying to police. If we have the prosecution's motion for sentencing, we'll cover it later, because in that motion, they illuminated how costly this investigation was. But I am still a little bit impacted by the prosecution's statement to the court when the defendant pled guilty on counts 2 and 3, that it was the defendant's lying to police that delayed them from being able to recover various dumpsters, and that those dumpsters had already been incinerated. It is a difficult fact in this case, and I wonder if the defendant hadn't pled to the dissuading police, if that would have come up. And I'm surprised it didn't come up in sentencing. I'm surprised it didn't come up at trial. If that is a fact that is known, it seems that that fact could have been put on the record, that on these dates, we saw which dumpsters the defendant went to. It surprises me that they didn't bring in a witness to say this dumpster was recovered on this day and disposed of and how. But I guess if the jurors are curious about the sentencing with the case being streamed, they can watch that and hear for themselves. Because there are still lingering questions, and I see them in chat and comments. There are still lingering questions about why the defendant wasn't made to tell anyone where Ana Walshe was. And I think it's because the prosecution knows. And there's nothing really that can be, there is not much that can be done, unfortunately, after the fact. So it was also really hard to hear the prosecution, just sad to hear, hard to hear. It was sad to hear the prosecution discussing how difficult it has been for the victims' friends and family to grieve and to have closure, because they have not been able to have a burial, and they have not been able to have religious ceremonies because there was no death certificate in this case. And I'm glad to hear that the prosecution is working with the medical examiner's office to try to get a death certificate. Normally there is a period of time that would have to pass before they can do that. But given the conviction and the evidence here, I think it is fair to do that now. And I hope they're able to do that, because a sentence, though it gives some finality to the court process, it doesn't really give victim families closure in the way that they might need. Because at the end of the day, what happened is just a bit too awful to really wrap your head around, and trying to process information is part of having some closure. And the facts of this case are a lot tough to process. With that, we're going to go take a look at what one of the jurors had to say, and we will go from there. Yeah, we will. All right, law nerds, let's do that. I appreciated the prosecution in this case. We only heard what, if any, like 3 times. I really liked the judge in this case quite a lot. It was a refreshing change. I think the defense did the best they can with what they have. I'm not always going to agree with what any attorney does, obviously. But I respect that they did the best they could with what they had. And I think Attorney Tipton made some arguments that I don't know if there are dots I would have connected. It's hard for me to put myself in having to be a defense attorney. I can normally look at a defense attorney, I'll argue this, this, and this. I could not have foreseen the arguments the defense was going to make today at sentencing, but it is also why I would be a terrible defense attorney. So I'm going to hold on to some of your questions. We're going to go take a look at that. Let me just go pull it up real quick. Kalusa said, my husband thanked me for making croissants. I told him, don't thank me, thank Emily. You're welcome. Also, mine is still here. We haven't gotten to it yet this morning, but that's okay. That's okay. We'll get there. All right. Do you think Brian told the truth to his lawyers? I think Brian probably told his lawyers the same story he told everybody else. What I know about fraud defendants is that they really do try to shift reality to their version of reality and tend to tell everyone around them that that is the reality and that is their version of reality. I would not be surprised if he also told his attorneys his version of reality, and that his version of reality is the truth. Much like Sarah Boone thought that if she kept saying not intentionally, somehow it would just be the facts. I see very much the same from Brian Walshe. All right. To all the law nerds who mentioned that there was a juror interview, thank you for mentioning it. I appreciate it. We're going to go to that interview. My thoughts and attention yesterday were A, on the work things we needed to do, and then B, on what was going on in courts in LA, so I could keep you up to date in the Law Nerd app. Hopefully those quick, let me know in the chat, hopefully those quick case updates in the in just a message through the app to you, not like a notification that there's a video. Hopefully those are helpful, because over the holidays, as I am not going to be streaming and taking some time with family before Griffin absolutely crashes out on me for working too much, I will send some of those notifications if things happen in court. I think given that this is wrapped up and that the other cases we have seen have wrapped up, I don't think there will be much really going on in court of import to the cases we cover. And if there is, we'll cover it as we get back to streaming at the beginning of the new year, because I have to give Team Baker some time off because it is much needed and they have worked very hard. They have worked very hard. We're going to give Team Baker some time off, but also EDB needs some time off, or we're not going to make it through. We're not going to make it through all of the cases we have coming up in 2026. We all need just a bit of time. So let me take a look at this real quick. Thank you Miguelina, for sending this story. Let's see if it looks like they are not on camera, which is fine. So let's see what WCVB has to say. They always do a great job in their reporting. And our local, we love our local media outlets that bring us the information that we wouldn't otherwise get. So
a jury of 12 reached.
Well, that's definitely louder than it is when we're in court. Let me gain that down just a little bit because, well, definitely louder than it's rare that I have to gain volume down. When does that ever happen? Never. All right, let's swoop. We'll do it again. That's better. Hopefully that's better.
Its verdict on Monday after 6
How's
hours
that
of
sound,
deliberation. And now one of those jurors is speaking exclusively with News Center 5 about the decision to convict the Cohasset man of first-degree murder.
I mean, the evidence on that case was, I thought, compelling.
His story about that she had sudden death in bed and he panicked and got rid of her body.
Oh, look, the very first thing that the juror who they interviewed, the very first thing the juror is saying is something that's not evidence that the defense said in opening statement. Right. Right. Like we talked about, it sticks in your brain. You're told it's not evidence to consider, but it sticks in your brain.
First-degree murder.
His story about that she had sudden death in bed and he panicked and got rid of her body. The jury did not believe that. So it wasn't really a question of whether
it wasn't an evidence. It wasn't an evidence. It wasn't an evidence at all. I love the jury just didn't believe that. Fair.
Not guilty. It was more a question of murder in the first degree versus murder in the second degree.
I'm not surprised by that.
The juror says while second-degree murder was considered, the panel agreed there was premeditation. She also says she's heartbroken for Ana's 3 children and hopes the family and friends will find some peace. Sentencing in this case is scheduled for 9 o'clock this morning here at Norfolk Superior Court. Reporting live in Dedham, Todd Kiske.
Todd, what time are you reporting live in Dedham? Does that say 5:07 a.m.? This was today? This was today at 5:07 a.m. Okay.
WCVB.
Some of you are saying there's more. There's not more on this video. This video is done. Let me see if there's another clip from WCVB because there's not more on this one. That's early. Let me go take a look real quick. So it's not something I met yet. Not something I missed yesterday. It was today. All right. I'm going to just take a look real quick and see if there is another video because they're already starting to put up the videos from today. Let's see. I do not see it on their YouTube channel unless it was a live. Let me take a look at their live and see if they have anything, but I don't see anything else on WCVB's YouTube channel. So, some of you were saying there's a longer version of that interview. I don't see it on WCVB. So, unless it was somewhere else, let me take a look real quick. Let me look one more place and see if I see another video. That's the press conference. That is a short clip. Oh, here we go. I found another video from like 17 hours ago. This is also kind of short. So if we end up piecing together some of the shorter interviews, chat, apologies. It just is what it is. This is with a different reporter, but I really wish we just instead of clips, there was just one place. But we'll take a look at some of those. All right. This is a separate clip from WCVB. It's about 2 minutes long. I'll keep looking to see if there's a longer one when we hear what the juror has to say.
What happened to her that night?
A juror on the Brian Walshe trial is...
Let's go back to all the way to the beginning. There we go.
Didn't deserve what happened to her that night.
A juror on the Brian Walshe trial is
accurate.
speaking with us over Zoom about finding the Cohasset man guilty of first-degree murder.
What led you to the guilty verdict?
The testimony and evidence.
The group of 12 rendered its verdict Monday after 6 hours of deliberation. Prosecutors presented evidence that Walshe killed his wife Ana 3 years ago in their Cohasset home, then dismembered her body and dumped her remains, which have not been found. Walsh's defense attorneys argued he found Ana dead in bed, suffering a sudden unexplained death, a claim the jury apparently did not believe.
The worry about that she had sudden death in bed and he panicked and got rid of her body. The jury did not believe that. So it wasn't really a question of whether or not we would find him not guilty. It was more a question of murder in the first degree versus murder in the second degree.
This juror tells us
Yeah, that
while
makes
some
sense to me,
considered
too.
second degree, they reached agreement that there was premeditation.
At any point when this was
makes
happening,
sense.
or even right before, Brian could have made a different choice. He could have stopped.
She is heartbroken
Didn't
for
deserve-
Ana's 3 children and hopes her family and friends will find some peace.
I pray that her
And that's where the premeditation bit comes in, right? That's exactly where the premeditation comes in. He could have stopped and made a different choice. Yes. Especially if the jury believes that a knife was involved, he could have stopped and made a different choice. 100%. 100%.
at any point when this was happening, or even right before, Brian could have made a different choice. He could have stopped.
Yeah.
She is heartbroken for Ana's 3 children and hopes her family and friends will find some peace.
I pray that her friends and her family are able to find some closure. I feel terrible. Ana's children will have to bear this for the rest of their life. It's just chilling.
It is chilling. I agree.
Now, you may recall that.
And that looks like about all the statements we have. I'll see if there's anything at the end of the wrap up from the tail of this is also from early this morning, but I'm glad that they had one juror who spoke out and said it was for us between first degree or second degree, which we chatted about a lot here about if that was what they were determining, and having that conversation about what is premeditation, which we have had a lot of those conversations together here too.
There was some indication that Brian Walshe himself would take the stand. He ultimately chose not to.
Some indication. There was much indication.
This juror tells us she does not believe his testimony would have made a difference. Live in Dedham.
I disagree. Brian Walsh's testimony absolutely would have made a difference. They would have come back faster. It would have made it easier for them to decide between first and second degree had Brian Walshe testified. It would have hastened the 6-hour deliberations and maybe cut that down or in half. It would have very much made it an easier decision for them to determine. So when we're looking at what the juror had to say over Zoom to WCVB, the juror noted that this was always between first and second degree, that the defense's argument that this was somehow a sudden death and then Brian Walshe found Ana Walshe and freaked out or got scared was not something that they gave any consideration or weight to, that their deliberations focused on which degree of murder, and that their determination was at any time in this, Brian Walshe could have made the choice to stop. And that really is a easy way to describe premeditation. Did you make a choice? Could you have made a different choice? Not an accident, not a chance. Could you have made a different choice? Could you have stopped? And if the jury believes that that knife in the kitchen was involved, that's not something that is necessarily singularly fatal. So even then, a different choice could be made. And prosecutors have argued premeditation in stabbing cases or cases where knives are used, that a different choice could be made in between different injuries without getting too graphic about it. But you see those arguments get made that somebody, when you have a coroner or autopsy report, you can go through, some of these aren't fatal. So you can make a choice in between the things that are not fatal. You'll see those arguments in shooting cases as well. People survive being shot. And so you'll see those arguments made if there were multiple gunshot wounds that a different choice could have been made between each pull of the trigger, and that was enough. So it's interesting to hear the juror also acknowledge that a different choice could have been made. So with that, you guys have questions. I have questions. We have questions. Law nerds, we should get to questions. It's a heavy day. It's sentencing is heavy because every time we get to the end of a case, you get to a verdict. If you get to a sentencing, you look at that sentencing and are like, it's the right result. I think this is absolutely the right result, but it doesn't undo anything. It doesn't undo the damage that has been caused. It doesn't undo the life that was taken. It doesn't undo the horrificness of the acts of Brian Walshe. And it doesn't undo the fact that their kids are growing up right now in state custody without their mother and essentially without their father. It doesn't undo any of that. So as we get to questions, Law Nerd, thank you for being here. I never say like the video. I always forget, but do the YouTube-y things. And more important than the YouTube-y things, get the Law Nerd app at lawnerdapp.com because that's where we'll keep you in the loop. And over the holidays, as I take a little time to, spend time with family under a cozy blanket with generally Fred on my lap. Though last night I got to bed way too late because I had Fred and George and I was completely cat trapped on the couch. It was not my fault. One cannot move in that circumstance. I cat trapped on the couch under a blanket. And that is part of what I will be doing over the holidays as well. As we kind of duck and cover and hope that both of my kids don't immediately get sick. And Griffin has a band performance tomorrow at school. So I'm very, very happy to go see G perform tomorrow at kind of his end of the year or end of the semester, end of the year celebration. So that will be very fun. Travis has decided to do band in addition to Winter Guard. So we have lots of music happening at the Baker house, which has been really fun. Our household is such sometimes so contradictory because all of us are a bit noise sensitive. Then my children also pick very loud instruments. They're like, noise is fine if I'm the one making it. And I'm just like, Travis is pretty good about not doing us in with the amp. So the Lauren, Travis is playing guitar this winter, and Griffin is a trumpet player. Griffin does not play the trumpet. I mean, he does play the trumpet, but Griffin is a trumpet player. Anyone who has spent a lot of time in band, yes. Griffin's a trumpet player. Blue Tempest said we call that cat jail. Yes. Full cat trapped. Wondering why there isn't an episode 3 of the Taylor Swift behind the scenes eras documentary. Why not? Stephanie, I think the I can't tell where the I is in that word, and I apologize. Said noise is fine if I'm the one making it. Griffin. Lexi, I know the chat was to the mods. Can we look into the John Travolta and Riley Keough drama unfolding? Yeah, it's on my list for the pod. It's on my list for the podcast. It is. I need to read it to decide, but it's on my list to look out for the podcast and see if I can at least explain what's going on, because I'm sure a lot of you have seen the headlines about John Travolta and who is the parent of one of John Travolta's kids, but I want to take a look and see if I can help explain it, because the lawsuit seems a little bit wild. So I've seen a lot of headlines about it, but it was on my list to see if I can help explain it. I need to take a look at it, but it is, I'm curious as to why it's in court, and if I can explain that, we'll cover it on the podcast. But also, my initial thought when I saw the headlines are just, why is this public? Like, why are we doing this? Because it's going to upend potentially a lot of things. So I'll see if I can help explain what's going on, or at least yell that it shouldn't be. So we'll see. All right. Let's get to some questions. Alley Cat, I've seen a lot of headlines about it, but I'm also confused. So I don't have an answer yet, because there were so many questions and the Reiner stuff was moving so quickly. And I also wanted to know who was handling it at the DA's office. I wanted to know which unit of the DA's office was handling it. I was also interested in the office politics of the Reiner case, because, well, office politics, where you used to work, are always interesting to keep an eye on. And so I was curious if it was going to family violence, which is another unit within the DA's office, or if it was going to majors. It's very curious to me that it's going to majors. Emily, this is like members only tea time. Well, sure. We'll be doing a members only early next week. We were going to do it today, but then things moved. But I was also very interested if it goes to majors, because Alan Jackson had been the head deputy of majors. So the attorneys in majors, I imagine, if they didn't work directly with Alan Jackson, a lot of them would have been downtown at the same time he was downtown. So he is going to know a lot of those DAs. They are going to know him, which can make conversations a little bit easier. Jackson's also going to know exactly what the majors DAs are looking for the defense to present to them. So it's going to be interesting to see how that case progresses with whether or not there are negotiations around it being a special circ, whether or not the arraignment being delayed changes the way that the defendant might plea. We'll see. Emmy said, unless they hated him as a boss, that was generally not the vibe in majors. So that was generally not the vibe in majors. And even at the DA's office, because look, trial attorneys are personalities unto themselves, right? Trial work, look, it takes a different personality as a lawyer to say, you know what? Grab 12 citizens to do jury duty. They probably don't want to be here. Sit them in a box where they have to listen to me for days and days and days and days and days. It's going to be great. Some lawyers are like, I would just like to type things on the computer. Leave me alone. Some attorneys are like, hostage audience. Fantastic. Let's do that. They didn't choose to be here. A lot of them don't want to be here. Let's do it. All right. And then some people, I go into prosecution and you look at them and you're like, you don't seem to like this. Why are you here? What are you doing? Go find a computer somewhere. Law has so many avenues for a career. Like, if you don't want to do trial work, it's real easy to avoid it. It's actually harder to do trial work. There are less jobs in trial work than there are not in trial work. So it always confuses me when people choose trial work and then you're just like, you don't seem to like this. Why are you doing this? It confuses me, but I don't get to make that choice. TIF Eddie says, what is on the 2026 court docket? Well, once I get it updated for the team, Emily, you're behind. Yes, I feel perpetually behind. Things will pop up. The things that we have been covering that are going to continue into 2026 in the Massachusetts, we are not done. I feel like we are still we're not even under the surface with the iceberg that is Massachusetts. I don't think the Karen Read civil trial or civil case will resolve in 2026. Maybe it will. We'll keep an eye on that. Corey Richins should go to trial on time in February. Alec Murdaugh's going to be arguing before the South Carolina Supreme Court. I'm very interested to see what the South Carolina Supreme Court does, because most cases I'm just like, appeals are for losers. Good luck. But of all the cases we've seen, Murdaugh's probably the closest to having a argument that might get him a new trial of any of the cases we've seen. So we're going to be keeping an eye on Murdaugh to see what the Court of Appeal does, or the Supreme Court of South Carolina. And then I need to look at what else is on the docket. There's a bunch of stuff we haven't circled back with, and then there will be new stuff. As facts come out, we will continue to cover the Reiner case. There were some other cases that have resolved that we have not really case closed on that we need to do. That is the initial early 2026, but Richins is going to trial starting early February. So it's going to be quick. Michelle said, anything with the TikTok psychic. I don't think the TikTok psychic's going to show up for their trial. So I don't know. We also have some Ron updates. I'm waiting for the court to rule. The court has not made a written order yet. When the court does, we'll do a full debrief with the Ron stuff. Don't worry. We will do Ron. Don't worry. We'll do that. At this point, it's not legally relevant, but there is just tea there. But there are other cases that I've kept an eye on that as they start to progress, we might add on to the docket. Nico the Kitty said, Emily, were there any resources for DA staff or court staff when dealing with these horrible cases to help the process? I want to make a joke, but it is not a joke about healthy coping mechanisms. We had happy hours, but no, we did not have a lot of resources for DA staff. I mean, we had health insurance, so you could go, you could seek support in your own way, though not everyone, when you have the availability to find resources, but your work is so busy that your working hours are taken up with work, it can make it a little bit difficult. So everybody kind of finds their own way. I hope that has started to shift a little bit as there was more conversation about the toll that stuff can take. The Saren said, question, can there be private practice prosecutors? No. The authority of the prosecutor's office is part of the executive branch, and there are not private practice prosecutors. However, prosecutors' offices can bring in a special prosecutor that handles one case. We saw that in Karen Read's second trial. We saw that in the Alec Baldwin case. Prosecutors' offices can bring in folks that are not hired by the prosecutor's office to prosecute a case. It's essentially deputizing someone. It's like, you've been deputized, you can handle this one case, but they still have to act under the authority of the elected DA and the prosecutor's office. So you can't be in private practice and say, I want to go prosecute cases, because you would then need to be hired by a prosecutor's office. So it is a branch of government. Defense attorneys, yes. Defense attorneys can operate in a wide variety of different ways. Prosecutors, not so much. Richard, thank you for the note earlier today. I'm glad we got to go take a look at the juror interview together. Ashley, party of one, said, I know there's good reason for the statements to be sealed, but my goodness, the poor kids. I agree with you. And yes, I think it's appropriate for the DCF statements to be sealed. The court has those. The attorneys have those. I don't know if the defendant will read that or not. but they have that ability, and that's tough. Juniper, you and others have asked, will the defendant be in federal prison first or state prison for everything? State prison for everything, because the larger balance of the sentence is in state prison. And then we heard the court indicate that the federal sentence is running concurrent to the state. So while he's serving his state sentence, the federal sentence is running at the same time. So either way, he would end up in state prison. So, Caitlin said, Lawnard's rock hoodie and purple shoes for court today. Enjoy court today. I hope you stay warm. It is a chilly one today, for sure. It is chilly and rainy here in Middle Tennessee. Purple Wolf, thank you for the gifted memberships, and everyone who gifted memberships. New members, we will have a members only stream at the beginning of next week. I've not even had a chance to look at next week's calendar, so I don't know which day, but we will have a members only early next week during the day. Tracy said, what he did didn't stop at Ana. The ripple effect is so far reaching. Sorry, I didn't get to read all of that. Is so far reaching so many other lives. Yeah, the defense argument was difficult. It was difficult. EDB, will you cover the art fraud case? Heard a rundown of it from Lawyer Lee. I did a rundown on the art fraud case. When did we side quest into the art fraud sentencing? It was a couple days ago that we did a brief look at the art fraud case. It was a lot. If it comes up when we're looking at the appeal, we can look at it a little bit more. A number of you have indicated that his mom also wrote a sentencing letter in that case. So maybe we'll just pull that one to kind of glean what we think might be said in this one when we talk about her civil case a little bit more. I'm waiting. There's some other rulings in the civil case I'm interested to see. So if we pull up Brian Walshe's mother's civil case again, I'll pull up the sentencing in the art fraud case again. But yeah, we looked at it a little bit. And yeah, I have heard that there is one other case that we need to look at with regard to Brian Walshe. So now that we are at the end of this, or the end of this part of Brian Walshe's case, we might pull up some of the things before. I tried to go in, especially with not knowing some of the earlier sentences, without my perception of the defendant built from other things that we've seen. My perception of this case was pretty minimal based on, well, nothing, because all of Tipton's arguments were really surrounding Proctor discovery. So I knew generally the facts of the case. Most of the facts, as I knew them, came from the prosecution making a factual basis when the defendant pled to count 2 and 3. So we had a little bit more information than the jury did, but I didn't want to go in with a ton of information that the jury didn't have. Some cases it's harder. The Corey Richins case, it's harder. We've covered that since not very long after her arrest. The Murdaugh case was the same. We knew a lot more information going into Murdaugh. Some cases, it is nice to go in as a juror and be like, oh my God, I didn't see that coming. Some cases we've covered from the beginning. Yoli Santiago said, is it weird that you get more time for lying than disposing of a human being? Yoli, of all of the cases that we have, well, all of the statutes I had looked at with improper burial, for lack of a better word, the sentences on those tend to be fairly low. And in California, because I've looked at this in Los Angeles recently, it never came up in my work in LA. It was never a concern in any of the cases I covered. I covered some cases that had stuff that everybody's like, wait, there's a code section on that. But that never came up. It's a misdemeanor in California. It is not a felony. It is a misdemeanor, which has come up in our conversation around the David investigation into the death of Celeste Rivas. Lots of you in the chat made your croissants today. We all got to have our croissants together, which was great. JM said we need to find more cases in front of this judge, though it would be great to be court watchers just in front of this judge at times. And maybe this will change as we go forward into the future. Maybe we just put it out there. If we have our own Lawnard court cameras down the road, then maybe we can pick and choose a little bit more what cases we watch. Right now, we're a bit at the mercy of somebody deciding to be a pool camera somewhere, but maybe down the road, we will just operate that ourselves. Bella Bull, thank you for the gifted memberships. Right now, I don't think we have the bandwidth to do that ourselves, but I can see a world where we could do it. It would require a whole separate wing of the business, but I mean, then we would at least get to pick the cases we cover and how we cover them. And then no extreme close-ups into like the pores on the defendant's nose. Megan said, I need that gingerbread house pillow. I found it at TJ Maxx. I don't know if that is specific to the TJ Maxx near me or if others have them. I got the gingerbread and the candy cane at TJ Maxx. That's where I got them. Darlene, I do not know what will happen with Ana Walshe's life insurance because there are more complexities to this case because she was missing. So I do not know. I very much hope so, but I just do not know. The complexities of how life insurance is paid out, especially in a case where there hasn't even been a death certificate, is hard. But I hope that they do. Based on this conviction, that should not go to Brian Walshe. It should go to the children. How that would pass through might be difficult too. Yeah, it might be difficult as well. Can we watch the judge's statement again without stopping? I will link the court feed down below. I think the judge's statement, stands on its own. Emmy said, I need the improper disposal count separated out too. There's the one where you put Mima in the backyard after hospice, and then there's this. That is... It's fair, which is why I think a lot of them are misdemeanors because they are not accounting for it being in order to cover up a crime. It is accommodating for a family burial or a funeral home that has lost its license or something. It's accommodating for other circumstances. It's not necessarily accommodating for this. This is more to cover up a crime versus just a person died naturally and we have buried them in a way that the state doesn't recognize. That's really what the crimes are for, or what they are for in California. The virtual juror, thank you, said III Interstate Identification Index. Again, we had different terminology for things in California, but what does probation say his federal case was and what actually is it? So, Ashley, thank you. Ashley said, happy holidays, EDB. Enjoy your well-deserved rest. Meanwhile, I upgraded my internet package on a cruise next week because I couldn't miss hanging with you at trial. And we were supposed to still be in trial and now we're not. So if you are able to turn off the internet, enjoy, because we'll do a members only Monday or Tuesday. I'll let you guys know this weekend when we will do members only once I have a chance to look at the calendar. I've been able to get through Friday of this week on the calendar and not much further because then Team Baker is on break and we will see. Cleopatra asked in the chat about I think she is a high school student on the cruise. I have that on my docket. I don't know the facts of that case well enough to tell you if I will or will not cover it. I don't have charges been brought in that case yet. I have seen headlines about the investigation, but I had not seen whether or not charges had been brought regarding the teen that had passed away on a cruise and then it was ruled a homicide, but I don't see if charges have been brought. There will be there could potentially be some difficult jurisdictional issues. Yeah, there could be some difficult jurisdictional issues, but it is kind of an asterisk on whether or not we'll look at it. It's just going to depend. So we will see. But jurisdictional issues might be interesting. But if the suspect is a minor, then there might not be any way to cover it. Because if the suspect is a minor, that could go through juvenile court, and the jurisdiction of cruise ships often follows where the cruise ship flag is. So the cruise ship, most cruise ships are flagged out of the Bahamas or elsewhere. I don't think I've seen a cruise ship that's flagged in the US. And generally, where the cruise ship is flagged is where disputes are governed, but each state might shift that. So there could be some complex jurisdictional issues. Just gonna leave that. So we've also got, I'm sure there will be an Adelson appeal at some point, and I have promised you that we would watch some of Charlie Adelson's trial, and we have not gotten to do it yet. So we will do that as well. We have lots, don't worry, we have lots of things we need to do. And we will do them as best as we can, because things will also continue to happen that we want to cover, which will bump back other things that we want to cover. That's just the way that it goes, because we definitely need to catch up. All of you are asking about Ron Ron. We talked about Ron Ron a little earlier, but yes, we will catch up on that. So, Law Nerds, it is the holiday season. It is a heavy day with sentencing. It is going to feel like a long 2 weeks of break, but don't worry. If you're a member here or a member in the Law Nerd Lounge, we all have a members only. If there are headlines around the cases that we have been immediately looking at, I will update you in the Law Nerd app. I will not be on social a ton. We have a couple missing days from the Depp trial that we need to go over too. I will not be on social a ton over the break because I'm going to spend some family time. So I will be communicating with you guys in the app. If we share some stuff on social, it'll be far and few between because there are times that a break is needed. Team Baker has not had a lot of breaks this year. And the time that I have been off from streaming, I've generally been traveling for other work-related things. So there has not been a lot of downtime this year. Downtime is definitely needed. And then as we are back in the new year, we have a whole list of things that we need to get to before Corey Richins goes to trial in February. Though I don't think they'll start evidence until the end of February. We have quite a lot to get through. And yes, we have an annual reading. We have an annual Christmas reading together. Yes, we do. Yes, we do. We have an annual Christmas book that we need to read. So we will do that on our members only before we get to Christmas. So for all of you, happy holidays, happy Hanukkah, happy Christmas. I will see you guys soon. I will keep you up to date in the Law Nerd app. Don't worry, we have some supercuts on the channel. We're going to have a new podcast for you on Monday. So there will be a new podcast on the Emily Show channel. Members, I will also record that with you guys. So members, I will see you in the podcast BTS recording and on a members only before we get into the holidays. I will be back streaming at the beginning of 2026. I can't believe it. At the beginning of 2026. Try to get some time off. Take some time off if you can. Take some downtime. This was a heavy case leading into the holidays. It's just heavy. However, I think that I hope that all of the friends and families involved can go into this holiday season and even into this New Year's Day knowing that there's been at least some resolution, that the jury has made their finding, that the defendant will spend the rest of his natural life in prison, and hopefully they can honor Ana Walshe on New Year's Day, because watching a trial that happened almost in real time with the time of year it is always just a bit more surreal. That might be strange. It might just feel that way to me, but as you're watching it going, God, this was happening just a few years ago this time of year, because we're watching those dates play out. It just is a little bit different. So I hope as they're coming up on the new year that they're able to celebrate the life of Ana Walshe and start to put Brian Walshe behind them. I came across something on social media where somebody was like, here's the best plan for the new year. Go ahead and write your, goals, hopes, and dreams on champagne bottles. And then as those things are accomplished, pop the champagne. And I had a visceral reaction to it. I was like, why the fuck would we do that? No, why would we do that? I don't want to do that. And I realized that normies are probably like, you know what? That sounds like a great idea to just like set some things out for the new year that you're looking forward to and planned some celebratory bottles of champagne. But in my brain, I was just like, oh, no. I don't want to do that at all. 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 So I felt so bad that I didn't put that in their comment section because we're adults and we can choose not to comment on things. But my visceral response was like, don't want to do it. 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 Law Nerds, you're the best. I will see you soon. I had seen a couple comments asking me to pull up a super chat. I must have already pulled it up because we don't have it here. So I saw the comment to bring it up, but I must have already, because otherwise we would still have it held. So that was brought up. I just can't say when, but I would have done that because I brought up just about everything. So Law Nerds, thank you. Have a happy holidays. Take care of yourselves. Take care of each other. Take some time off from all of the heavy. It's okay to take a step back. And, well, maybe I'll have some time to make some poppy seed bread and share the recipe with you guys, because that's one of the things I look forward to over the holidays. Lots of time spent in the kitchen, not as much spent time on the online. So Law Nerds, take care of yourselves. I'll be thinking of you. Happy holidays. I can't believe I'll see you in 2026. I'll see you in 2026. Team Baker, thank you for adding a December trial to the docket. I know it is a ton of work leading up to the holidays. I appreciate it. I'll see you guys soon. Thank you, mods. All right, let's go. Have a good one, you guys. It's time to roll the outro for the last time in 2025. Members, I will see you. Well, I'll see you a couple times before the holidays. Law Nerds, take care. Bye. Hey there, I'm lawyer and legal analyst Emily D. Baker. And Emily, that's the intro, not the outro. It means hello and goodbye, Law Nerds. It means hello and goodbye. It means hello and goodbye. What would the end of the year be without streaming as dynamic? Streaming is dynamic. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.